Folks, we're back. This is Steve Sanson and Stephanie Phillips with another episode of Veterans in Politics. Today we have David Gibson, Jr., Clark County District Court presiding judge over the Family Division, and he's representing Department L. But before we get to Judge Gibson, Jr., Ms. Phillips.
Thanks, and thanks everybody for joining us. Thanks to all of our sponsors. We have Semper Fi Heating and Cooling. It is so hot out there. If you need your system checked, give them a call. Their website is callsemperfi.com. Callsemperfi.com. We also have Mayor Michelle Romero. She is Henderson's mayor and she's running for re-election. Her website is votemichelleromero.com. votemichelleromero.com. Jump on there and check out her platform. Also, we have Cody K. Whipple. He is a congressional candidate for District 4. His website is codykforcongress.com, and that's the number 4, codykforcongress.com. Also, don't forget to get your copy of Steve's book, How to Navigate Nevada's Family Court System. If you are a litigant and you don't have an attorney or you can't afford one, this is a self-help book and it will help you get through that system. You can get a copy on Amazon. It is $14.99. Also, grab your tickets for our Valentine's Ball, which is happening February 7th of 2026. We have extra early bird tickets on sale right now. Super cheap, never sold them this cheap. They're $99 and there's only so many of those to go around. And they are on sale for that price till the end of August. And then in September, they go up. So make sure you grab those. Also check out our merch store. It's vipimerch.com, vipimerch.com. We have a whole bunch of stuff, fun stuff on there for you to take a look at. And I have to give a shout out real quick to Judge Jonathan Cooper. We were in his courtroom today and he was great. We had a really good time. Also Judge Yeager, we were in her courtroom as she was doing Veterans Court and she was awesome. She was very compassionate and great with all of the people that were there. For my rant, Child Haven, you guys are on the hot seat. And again, what we say in our rants, the signs we have up, has nothing to do with our guest. It's not their opinion. There's no endorsement. They don't even know what we're going to say. In fact, Steve doesn't know what I'm going to say even today. Child Haven, one of our family court litigants that we are helping, their kids were put in Child Haven due to a overzealous CPS worker who, in my opinion, made up a reason to pull the kids out of a perfectly good home and move them into Child Haven. Made up a reason there was imminent danger. There was no danger whatsoever. But regardless, so they go to Child Haven and one of the children has a medical condition that requires medication. And if they don't get this medication, it could be life-threatening. And the condition that this child has, one of the workers at Child Haven told the mother, we don't take children with that particular medical condition. So why was this child dropped off? And the CPS worker dropped this child off apparently without this medication. Child Haven could not tell the mother if they were giving the child this medication. They don't release medical records to the parents, or at least this particular parent. You have to go through the caseworker in order to get medical records, which to me, that's violating a parent's rights. I think that those medical records should go directly to the parents about their children when their parental rights are intact, regardless of what the status of the case is. And also, I would just say, Child Haven, it doesn't take a whole lot to have good bedside manner, so to speak. When people call, be nice to them. I called and I wanted to know what your policies were because they're not on your website. And I think all of policies should be transparent to the public. After all, taxpayers pay for your agency and your staff. So it doesn't cost anything to be nice to people or to the parents, because the parents are already in a terrible situation over there. So be nice to people and call back. I left a message for Renetta. I never received a call back. There's probably more, but I will cut this short. But I would say this. We're going to have more on CPS tomorrow coming. And I would encourage the governor to start a citizens review board on not only CPS, Child Haven, and DCFS. so that these people are held accountable to the Nevada taxpayer. Thank you very much.
Are you done, Ms. Phillips?
Yes, I am.
Okay. Judge Gibson.
Yeah.
How you doing? Thank you for coming.
I'm doing fine, thanks.
Could you tell us about yourself, sir?
Sure. I'm currently a district court judge. I'm currently the presiding judge of the Family Division in the 8th Judicial District. That's a position that I've held for about 3 years now. I was appointed at the end of 22, when our previous presiding retired. Prior to that, judicially, I started out on the bench as a hearing master with the 8th Judicial District, overseeing a calendar regarding child dependency or abuse and neglect, as it's referred to. That was 2012. I received that appointment. I was a hearing master for 6 years, and then with the vacancy in Department L, I applied for and was appointed by Governor Brian Sandoval to fill the balance of that term. Ran unopposed in 2020, and currently coming up on the end of my current term. Prior to that, I'm born and raised in the Vegas Valley. I was born in Henderson, Nevada.
This is your first term, right?
This is my first complete full term. Yeah, I had about 2 years left of the previous term that I finished out. So all total, I'm coming up on about 14 years on the bench. Prior to that, I was a general practice private attorney. I graduated from Boyd School of Law in 2002 and passed the bar that same year. And then I had my own practice opened within about 1.5 years of that. A few years later, I joined up with a few friends. It's now Mills and Anderson, and then it was Mills and Mills. Was there for a couple of years. Went back out on my own for a few years, and then sought the position of hearing master. So while I practiced, I did a variety of things: family law, criminal law, some civil and business type of stuff. I went to Basic High in Henderson. Graduated from UNLV.
Went to Boyd?
Went to Boyd. Yeah, I'm Nevada grown and educated. And, just come from a long line of people who have sought to serve this community. Several generations of my family have served in different capacities.
So your dad was a justice of the peace for many years in Henderson.
Yeah, previously a hearing master in family court as well, and then elected to justice court in Henderson. I think he served 3 terms or so. He just recently retired. Mm-hmm. And then my grandfather was
I enjoyed your dad, by the way.
Yeah, he's a good guy. Yeah. He is a good guy. He's now trying to enjoy retirement. It's a little.
Was he fishing?
He's traveling.
Gambling?
No. We're not big gamblers. You grow up here and, you stay away from that, I guess. But prior to that, my grandfather was a legislator. My great-grandfather was involved in a lot of community boards and different things like that. And so there's been a tradition in the family to serve.
And your uncle was mayor of
My
Henderson.
uncle is Mayor of Henderson. Yeah, he's currently a commissioner in Clark County. Yeah, so that's all the same family.
But he doesn't want to retire.
He's got one more in him.
I hope he's got one more in him. I obviously can't endorse any parties or anything, but I can tell you my uncle's a good man, and he's an intelligent person, and he really understands.
He's like
what's going on. I think that my dad and I are more known for being a little more irreverent, I guess. But Uncle Jim's a funny guy. He's got jokes.
Oh yeah.
He's a good guy. He's fun to be around. Yeah. So I'm a husband and father. I've been married for a long time. Let's see, I hate to catch myself in calculation, but we're coming up. We just celebrated our 28th wedding anniversary. Our youngest son, I've got 4 kids. My youngest son just graduated from high school. And so
empty nest.
We're on the verge of empty nest. Yeah.
Mm-hmm. Yeah. So you're the presiding judge over the family court.
Yes.
What are your responsibilities for that? And explain what the presiding judge does.
Okay. Well, in addition to my own calendar, my primary assignment is Department L. And
for Lucky?
So you can say that, I guess. My calendar is primarily our most vulnerable kids in the child welfare system. So I have the 4 and under category. Along with that, I also get the cases from a special unit at CCFS that deals with near fatalities, regardless of age.
Explain what that means.
It means that if a child has been harmed and was either, but sometimes it pulls in where there actually is a child death as well, but where the harm was sufficient enough to make it threatening to the child's life, then those cases come before me as well. Just because I think there's a specialized unit for it, because at that point there's an idea that whatever abuse and neglect was involved was severe.
Is that harm by the parent or the guardian?
Yeah, parent or guardian, whoever the adult that's responsible for the child is.
And how do you determine if the parent really did do whatever they're allegedly accused of?
Right. It's an evidentiary proceeding. So it's got several steps along the way.
What are those steps?
Clark County Family Services is required to make reasonable efforts to prevent or removal of a child from a home. And so based on their own internal guidelines, best practices, federal guidelines and rules that govern how they conduct their investigations, if they determine that a child may need to be removed, they will oftentimes submit for a warrant to go and remove the child, which will have what you would basically expect in a warrant application, a basic set of factual allegations. If they rise to a level that presents a present or an impending danger, then a court officer, a judge, will review that, potentially sign off on it. They're not required to obtain a warrant if there is an indigent circumstance, as with any other seizure. If it appears that the harm is actively happening or going on, then they're obligated to remove without seeking prior court approval. However, once a government agency like CCFS interferes with the family in that way, they are required to bring the case before a judge. But that'd be me or 5 other judges that hear these cases.
Who are the other judges?
Judge Pickard, Judge Giuliani, Judge Tootin, Judge Bailey, and Judge Forsberg. So those are our 6 primarily dependency assigned judges. We also, under one judge, one family, will hear related domestic cases to those cases as well. Similar parties will pick up pretty much everything as do with the family.
So you could terminate parental rights. Right?
That is one of the permanent safe options that statute allows, but there is a lot that has to happen before you get to that point.
And what's that threshold? What has to be met in order for you to say, yep, your parental rights?
To get to a point of termination of parental rights.
How bad does it have to be?
Okay, you have to, at that point, at least under 432B, which is the statutes that guide what a dependency judge is doing, there are grounds for termination of parental rights that are outside of child welfare involvement. Primarily, those come in terms of abandonment or serious neglect or abuse if it can be proven. The burden of proof is clear and convincing evidence. So what happens is, in a child welfare setting, the Clark County Family Services is first required to make reasonable efforts to prevent the removal of the child. Have a judge review that within 72 hours. If the judge determines that there is reasonable cause to have removed the child. So it's a very low burden. It's lower than probable cause.
You think it's too low?
Well, I don't have an opinion on that. The legislature decided, okay? It's one of those things, and historically, if you look into child welfare, there are lower burdens of proof in child welfare cases because legislatures made a judgment call that when it involves the safety of a child, that I don't want to say err on the side of caution, but that is kind of the colloquial way people have referred to it over the years. But what it really is it's a relaxed burden to ensure the safety of the child until more scrutiny can be applied to it. So the 72-hour hearing, you're typically provided with a packet, a report that has in it the factual allegations and any of the investigation conclusions and notes that have been taken up to that point. During that hearing, you also determine if there are any updates that have happened in the meantime. It all moves fairly quickly. At that point, a judge is required to make a judgment call if there's reasonable cause to believe that continuation in the home would be contrary to that child's welfare. And so you have to make a judgment call at that point. What that then triggers is an obligation for the state to make a determination in conjunction with CCFS as to whether or not the court should be overseeing their involvement with this family for a longer period of time, meaning should the child remain under the court's jurisdiction. They have 10 days to file a petition. And petition's like any other charging document, except for this is a civil matter. So it's not like a criminal information. Instead, it's typically 1 to 2 pages, maybe 3, bare factual allegations as to why that child needs protection. That triggers an opportunity for the parents to either admit or deny the information in that petition, or to, at this point now, based on a recent case ruling, they can enter a no contest plea in that context as well. That sets them, if it's a no contest or an admission, typically there has been some negotiation that has reworded the petition to frame what everybody agrees are the provable facts. And the burden at that level is preponderance of evidence.
Do you ever get a case where the attorney didn't provide sound legal advice and the parents didn't really realize what they were signing in some of these, because these attorneys are just they just go through these clients so fast? Mm-hmm. Do you have like deer in headlights, looks on the parents' faces, like they don't understand what they're signing?
Yeah. I get
Do you get saying. That sometimes?
Well, obviously I can't comment on any preceding cases or any of my cases that I've dealt with. But in general, there's always a risk of that in any situation. Sometimes it's a matter of you get what you pay for. Sometimes it's a matter of, many of these parents are represented by appointed attorneys. Yeah. What I will say though is it's a mistake to think that an appointed attorney is not a competent attorney. Very often an appointed attorney has vastly more experience with the case type and the law than your run-of-the-mill private attorney does. And the county has an office that they maintain for appointed counsel. They're expected to vet these counsel before they contract with them. Obviously, from the bench, I have duties. If I see a dereliction happening, I'm obligated to report at the state bar. What I can say is it's not outside the realm of possibility that can happen. However, from the bench, I take great lengths to make sure that it doesn't. Whenever I'm receiving a plea from a party, I sufficiently canvass them to make sure they understand what they're doing. I give them repeated opportunities to tell me, this isn't what I want to do. I give them repeated opportunities to tell me, I don't really understand what's going on. And if I hear that from a party, then I'm not going to accept the plea, and I'm going to require that an evidentiary proceeding go forward. I would say that my other colleagues in dependency also have the same practice. And so from a point of quality control, like you're inquiring about, we have a lot of things in place to make sure that it doesn't happen. Doesn't mean it doesn't happen.
Right.
The attorneys are admittedly carrying large caseloads. I think every practicing attorney out there is carrying large caseloads. I remember when I was practicing, you were always on the verge of, is this too much? Can I take this next case? And you're weighing, can I pay the bills if I don't? There's all kinds of things that go into the calculus as to why an attorney would take a case or not. I never took a case that I was not competent to take. I think that's an attorney's duty. As a judge, if I see a dereliction on the part of a counsel, I think it is my role to call it out and to make sure that it doesn't go forward any further.
How come some of these cases take so long? Because we've court observed a ton. We've been in your courtroom. We follow some of these cases because we have family court litigants that come to us and tell us about their cases. But how come there's so many status updates, like every 4 weeks, 6 weeks, 8 weeks? Meanwhile, the kids are still in the care of the state. And then it takes 6 months to get to an evidentiary hearing, and the back and forth and back and forth. How come there isn't a time, like something that's already laid out, that you have to rule within a month? You have to get that evidentiary hearing. How come some of these cases are 6, 9, 12 months? Meanwhile, these kids are in someone else's care, and maybe these parents are innocent in some of these cases and they haven't done anything, and there's conflicting, medical reports, but then they're away from their kids. How does that get sped up?
That's kind of a lot to unpack, but I can for you.
Yeah.
Specifically, there are statutory deadlines, timing wise, where things have to happen, and they should, in most cases, happen within those time frames. On a finding of good cause, there can be delay, there can be extensions of time, and good cause is a variety of things. In a case that is heavily evidence specific, say a lot of medical records and things like that, sometimes it moves at the pace of the lawyers being able to obtain that information. They're with HIPAA, with all kinds of other different things. Sometimes it's hard to get the needed reports and opinions out of the doctors that could then help shape an opinion. And you balance that against the legislature's timing rules that they've enforced in these. Like I mentioned already, 72 hours for the court to hear it first, 10 days for a petition to be filed. Within 30 days of the removal, there is supposed to be an opportunity for the parents to at least admit or deny. And then from there, evidentiary hearings are supposed to be set in fairly short order. As in any other litigation, if the attorneys appear and say, we are not ready to proceed because of A, B, and C, then the court has to make a determination if that's a good enough reason for the delay. I think I'm known among the bar to not put up with a lot of delay. Most of my cases are adjudicated with a decision on what the facts of the case are within that 30-day period, rarely outside of 45 days. And we also have a 45-day deadline for disposition on the case. So once a case is adjudicated, it's got to be disposed of, meaning jurisdictional findings and things have to be made on the record within 15 days of that. And so there's been a lot of effort in this jurisdiction over the last 20 years to get our cases in line with the guidelines that run these things under our statutes, but also under the federal guidelines that affect funding for public institutions and things that work with child welfare. I think statistically within the 8th, we are what you would call a model court, meaning we move things much faster than other similarly sized, similarly staffed jurisdictions. And within the area of family, of dependency, of child welfare, we meet those statutory deadlines upwards of 90% of the time. So the ones that you see, the ones that are delayed, I'll say tend to be delayed much longer than they should be due to a variety of things. But with respect to your question as to why does it take so long for kids to get back to parents? Mm-hmm. That is determined very frequently by the level of cooperation and interaction that the parents are having rather than the other way around. They are typically receiving the necessary referrals that will address the danger issues that have been identified or adjudicated in the case within the first 30 to 45 days of the case. And then the 6-month hearing and the annual hearing are dictated by statute. We have to come back every 6 months on those cases to make sure that there's not unnecessary delay. In the meantime, though, the Child Welfare Agency is empowered by the court that in their regular assessments of the current safety situation, except in a few very narrow circumstances, if they determine that the home is safe, then they have an obligation to make reasonable efforts to return those children to the home. So in the vast majority of these cases, you will see them where the parents are cooperative, you'll be seeing the reunifications very early on in the case. The court is, and you made mention, what if somebody might be innocent or might not have known what they were doing? That is an issue of fact. It can be determined in the course of hearings. Frequent status checks and things are actually meant to shorten the time to get the kid home rather than lengthen it out, because if the court is setting those status checks short of those statutory benchmarks, that means the court is keeping a close eye on the case and trying to get that kid back into the home. Where we run into issues, though, sometimes is we are bound by the law of the case. So at the time that we take a plea, and that's why we may take such great concerns, when somebody's admitting something, we go through a canvas with them that says, you understand, we're not going to hold a trial. We are going to use the facts that are being stated in this petition as the facts that govern this case. And once that's adjudicated, whether it's by a full evidentiary hearing or a trial, or on a party's admission or failure to contest, that becomes the law of the case, and the judge can't wind it back and say, oh, you know what, actually that was wrong, we got to go this way. With few exceptions, 60B motions and different things like that, new facts arise, something comes out where a fraud on the court's been perpetrated, you can actually demonstrate it.
Rescind that?
Then it can be changed, but it's under those very narrow circumstances. Otherwise, a judge, we're not allowed to go out and do our own investigations. We're not allowed to do any of that kind of thing. We receive what people input, and then we have to apply the law to it and then put it out. And once it goes out, that becomes the law of the case. And so if at one point someone was admitting something and then later they're denying it, the denial, unless it's supported by new evidence, is not something that we're allowed to consider. We have to focus on the law of the case. And so in those circumstances where maybe a parent, and I understand denial in these cases. I used to represent parents in these cases. I used to have nightmares myself that CPS was knocking on my door.
You do a lot of that.
You can't avoid that when you're involved in the system. And I mean, literally, it was a recurring nightmare when I was representing parents that CPS was there to come into my house and take my kids. It's a traumatic experience for everyone involved. Yeah. And we're really sensitive from the bench in those cases to try to minimize that trauma to everybody. But the primary focus is that child's well-being. And if we have facts that have been determined that child was put in danger or was harmed by somebody's action or inaction, then what the law requires us to do is to create a plan that helps that parent find a roadmap back to having their child safely in their care. And we're required to give them a reasonable amount of time to do that. And the department is required to make reasonable efforts to make that happen. If, though, you get a year into this case, and that's what that annual hearing's for, if there are not what's called compelling reasons, if there's not a compelling reason to keep reunification as the primary plan for the parents, the court has to explore other alternatives, which can be things like guardianship, the child themselves aging out of the system is called an other permanent planned living arrangement, an alternative placement, fictive kin, grandparents, people like that.
Or if a 16-year-old getting married, what is that called?
Right, emancipation.
Yeah.
Or termination of parental rights. Termination of parental rights is considered the death penalty in civil law.
That usually never happens, right?
Well, it happens all the time.
Oh.
Yeah.
Shouldn't it be more rare?
I terminate rights.
Should that be a tribunal?
Every month.
Every month?
Should that be a tribunal, or should it be left up to one person to make that determination?
That's also a determination that needs to be made by a legislature and the people of a state. I think that a jury trial in a termination of parental rights case would, one, complicate the system quite a bit, because I think the average person is not trained and doesn't understand the child welfare issues, right? Everybody's got a story. My dad used to take me out back and whip me with a switch, or, dad used to unbuckle the belt, that kind of thing. I grew up in a home that employed from time to time corporal punishment. I was never abused. As time has gone by, though, I think you'd acknowledge that these younger generations, and as time goes by, there's less and less tolerance for any kind of corporal punishment. Yeah. And in Nevada, the law is still, you cannot disfigure, or harm the child that way. And so when something leaves a mark, that's typically considered disfigurement. And so it's a low threshold and it gets lower as every generation goes by. Heck, some people think
probably what's wrong with our
some people think putting someone in public school is abuse. I mean,
Gosh.
There's everybody's version of abuse, and it's a wide spectrum is out there. However, these terms are statutorily defined, and they have legal precedent that I am bound to follow. And so, as I'm working with a family and trying to get them on the road to reunification, the legislature in the state of Nevada made the determination that, and the federal government's made the same determination. Our laws mirror the federal guidelines very closely. At 1 year, if the parents haven't sufficiently adjusted their circumstances to make reunification something that can happen in the foreseeable future, then the court can't make compelling reasons finding to keep reunification the plan. At that point in time, very frequently a different plan is put forward as the primary plan. Now, I will say, by and large, Clark County Family Services will continue to work on what we call concurrent planning. So say that the parents haven't quite done enough to give the court compelling reasons to keep reunification of the plan at that 1 year hearing. TPR might be the primary plan at that point, but reunification is also the secondary or concurrent plan. And they will continue to offer services to those families. The thing is, once a compelling reasons finding has been made, it does shift some more burden to the parent to really be a self-starter and go out and get it done. They know that TPR is on the horizon. If it went by the statutes, we'd be terminating parental rights at 18 months on every case. And we don't do that. I make compelling reasons findings fairly regularly. It's only in cases where, and what you don't see, and what's difficult to see because of the nature of these cases and what is open to the public and what isn't. In Clark County, we have nearly 3 times the number of child welfare cases than the entire rest of the state of Nevada. Reno's second, and it's a far second. We have at any point between 2,000 and 3,000 kids in care. And those represent probably about 15 to 1,800 cases. In 2014, we held, I think, just over 1,400 removal hearings. So that means that there were 1,400 new cases added potentially to the existing caseloads that we have. And each of our judges are carrying at any given time between 350 and 500
You're
cases.
probably going to lose one of those judges. I heard Robert Tootin is not going to run for retention.
Yeah, I
or
can't really
re-election.
comment on what each judge is doing.
I'm
What
just
I
saying that's
can
what I
say-
heard.
Yeah,
I'm just
what
saying
I
that's
can
what I
say
heard.
is, yes, judges who have experience in this area are at a premium, and it creates for me as a presiding judge a difficulty because should I lose 1, 2, or 3, either to retirement or an election, then I'm in a situation where I may be bringing someone in who has no experience at all. But by the same token, hopefully either the appointment process or the election process is going to give me someone who is qualified to handle any aspect of the family division. And there's a lot of things that we hear.
So as the presiding judge,
Yeah.
do you put judges where their strength is? And before you comment, I remember we had Judge Charter in here, and she was saying that she's strong, and I think it was, what was it? What did she say?
She had a dependency.
Yeah,
She had a
and then they
dependency
move her
assignment
over
before I
Yeah.
reassigned her to domestics.
Yeah, then she was complaining about that. So
Yeah.
my question is,
Well, I in conjunction with the chief.
you
made her-
weren't the chief then, were you?
Well, I was the presiding judge, but the chief made
Chief
the
White.
chief made the
Weiss.
Weiss made
Yeah.
the ultimate call on the
Right.
reassignment.
Okay, so it wasn't you.
Well, no, I recommended the reassignment.
Okay.
Obviously, everybody's got their point of view on this.
Absolutely.
There's arguments on both sides as to whether we should have a highly specialized judiciary or if it should be more general. From a presiding point of view, I would be far happier with more judges having a broader base of experience and exposure so that we can survive large turnover in potential in election, retirement, and different things like that. Our bench is aging. We have judges on the bench that are multiple term judges who are getting to the point in their career that they're thinking about going ahead and resign and not running again or retiring. And so logistically, it causes an issue for you. And so my goal has been to try to train and educate as many of our family court judges in as many aspects of our jurisdiction. Family law covers not only your typical run-of-the-mill divorce or custody case. We have juvenile delinquency. People refer to that as juvenile crime, basically, right? Truancy isn't even delinquency anymore. We're talking about things that, if the child were an adult, would be charged as a felony or misdemeanor in a criminal court. Okay, but it's still a civil court. We treat kids different. We try to rehabilitate them and not stigmatize them with convictions and things like that. That's its own title, but it's part of the family jurisdiction. So you get anything to do with parentage, anything to do with custody, visitation, divorce, property division, all of that is part of our jurisdiction. The delinquency stuff, the child crime, if you want to call it that, and then dependency. which is what I'm in, child welfare, abuse and neglect. Although I have had a dependency assignment, a delinquency assignment, and a general domestic assignment. I've sat in virtually every aspect of what our court does. And then we also have guardianships, both adult and minors. And so we have a wide variety of cases that we hear. The state legislature determined that in populations of a certain size, there should be a family division consisting of at least one family judge or more if you need them. And then that family judge and anybody that puts themselves forward to be a family judge, in my opinion, should at least have a working knowledge of every aspect of it or the ability to learn it in short order. Otherwise, why are you putting yourself forward as a public servant if you can't serve the public in every aspect of what you're asking them to elect you to? And so, in my opinion, and traditionally in our courts, every new judge typically starts out with a purely domestic calendar, which is the heart of family jurisdiction. That's what it was created for, essentially. All of us should be able to handle those kinds of cases. And traditionally, with the exception of one or two judges in the entire history of this division, every judge has started with at least a year to two in just domestics, and then a reassignment potentially to a specialty.
So Judge Gibson,
mm-hmm.
you deal with DFS a lot, right?
Every day.
Okay. So this is a good question.
They're CCFS now, Clark County Family Services. But I'm still getting used to that. But yeah, every day.
You know, I've been back and forth in the courthouse for many years. And I wrote a book on family court. I even wrote another book. My first book was on small claims court and collection law.
Oh, okay.
Did you see that book?
I think I remember that. I think I remember that back in the day. Yeah.
So over the years, I have heard that Department of Family Services, especially CPS, I have heard that they fabricate the truth. Mm-hmm. A lot of the caseworkers, they lie. They search people's home. They show up unannounced. Mm-hmm. They show up with cops and they don't have a court order.
Right.
How do they get away with all that?
Well, what I can say,
and so before you answer, there's one more.
Yeah.
And some of them are not even have the education mm-hmm. in that field, but yet they're placed in there.
Right.
So how does these CPS caseworkers have so much power? Because if they show up to my door, I'm going to slam the door on them. That's just me.
And
2 o'clock in the morning to take my kid.
Usually legally can do that. Okay.
Show up 2 o'clock in the morning to take your kid?
Well,
search your home without a warrant. Even cops need a warrant to search your home.
Yeah. Let me there are so many issues involved in this.
What I can
tell you, in my experience, the caseworkers that I've dealt with and before I've been on the bench for 14 years dealing with these cases all through that time frame. I represented parents who were having people knock on their doors for 10 years before that. I've got decades of experience. And I would be lying if I said I haven't come across caseworkers who were unethical, who lied, who cheated and stole, right? I have cross-examined caseworkers in that situation and exposed them. I have rooted that out myself.
Some of them can't even control their own emotions. They're biased.
From time to time.
From the bench, you've done that too, not just as a lawyer.
From the bench,
so
I have determined
jurisdiction over some of these.
From the bench, I've determined that the caseworker who's testifying is not telling the truth. Okay, that has happened. What I can say is it's a very small percentage, though. By and large, the caseworkers that I've interacted with over the years are doing the job to the best of their ability and doing it legally. With respect to the warrant question, that wasn't resolved in Nevada until about a decade ago with a case that came out of Reno that required that in the absence of exigency, that you cannot remove a child without a warrant. Okay. And we immediately reacted to that in Clark County and put a warrant system in place. Which is another issue altogether. But what I can tell you is the six judges that hear dependency cases, we are on a rotation week in, week out, 24/7 a day on call to handle the warrants that come in. 16 weeks out of the year, every single one of my 6 judges is on call 24/7 in addition to the regular judicial duties to handle those warrants. I, as the presiding, and Chief Weiss as the chief, we are the 3rd and 4th place that you call if you can't get the the person who's on duty and the backup who's on duty. And then sometimes I'm pulling double duty there because I'm both the backup and the primary. So there's a lot of work that's going on outside of the courthouse for our judges. We look at those warrants and we scrutinize them. I have denied warrants. I have seen no reasonable cause to remove a child, and I've told them, you're not getting a warrant on this one. And I reject warrants several times a year. There are a lot of warrants, though, where they have crossed their T's and dotted their I's and at least done a minimum amount of investigation that under our laws require them to get involved. And with respect to entering a home on a welfare check for a child, you don't need a warrant for that.
I'm talking about removing a child
right.
2 o'clock in the morning.
Removing a child 2 o'clock in the morning, if that's what happens.
Without a warrant.
Well, is that
without
because
a warrant,
the person opened the door and
right.
allowed them in?
Mostly yes.
So in that case,
Yeah,
they don't
open
have
their
to
door.
Their guideline, well, obviously I can't give legal advice
Right,
as well,
right.
but their guideline is that if it is actively happening in their site, they have to remove. That's what you call an exigency. So if you walk into a house, for instance, and there are so many obvious hazards
Right.
to the well-being of this toddler.
Dead body on the ground.
Yeah, or this toddler that's walking around and there's guns at this height, or a crack pipe, or
Of course.
they have to take the child out, and those are the ones that happen at 2 in the morning.
What
Because those
if
are
there
the hours
isn't-
that people that are in that kind of a lifestyle are operating on.
What if
And
there
so-
isn't any and the child is perfectly fine, sleeping in their bed, no harm, no bruises, no blood, no trauma, nothing, perfectly peaceful, and they were a sibling of another child
Okay.
that was pulled, but nothing happened to this child? Do they
Right.
just pull all the siblings just cause?
Typically, it depends. It depends on if you can articulate a present or impending danger. Okay, and from there, in their terms, okay, they adhere to a set of policies, abbreviated as SIPs. I can't remember what it all comes out to, but it's a safety protocol that they put in place. Okay, and they make an assessment initially with some categories that determine whether there's present or impending danger. One of the calculations formulas that they have to apply is they have to weigh protective capacity of the parents and the child. Even like a 16-year-old is more protective of themselves and able to protect themselves more than a 3-year-old, right? So they have to weigh the protective capacities that are present versus the dangers that are present. And when you have a similarly situated child who's within a few years of another, say you have a toddler and a 5-year-old, and the thing that you've been called out on is that toddler's got serious injuries of some sort, visible injuries, internal injuries, whatever it might be. Their guidelines state, and federal guidelines are the same way, that 5-year-old is potentially exposed to the same danger. It may not be. You might have parents who favor one child over another, and the one child catches everything, the other one doesn't. But
I caught everything.
right. But they have to make a determination right then. The other thing that can happen is flight risks can happen, right? You take one child, if that's the child who's not the favorite, the family might just flee. There's all kinds of things that they've got to take into account, right? And they need to be able to assess that child too, because though there might be physical injuries on one and not on the other, it doesn't mean that there weren't at some point. It doesn't mean that child, when that child was 3, wasn't getting regularly mistreated. And so they're weighing all this. Exactly.
That's why it might have happened.
That's why they got to come before a court within 72 hours.
Yeah.
And they've got to say to us, look, this is what justifies the removal of both of these kids. I have, on occasion, said, you have reasonable cause to remove this child. You don't have reasonable cause to remove that child. And by the same token, though, children have a right to remain in their sibling groups together with one another, to rely on each other when the parents can't manage it. There's all kinds of things that weigh into the decision. So it's really hard, other than on a case-by-case basis, to make the determination and to make a broad judgment about the majority of those caseworkers that are out there doing it. But you do bring up a point. Caseworkers that work for Clark County Family Services are not required to be licensed clinical social
There
workers.
should be.
They
Anything
should be.
along that line. They have their own
Background checks, everything.
They do have to do that. They have to do all of
I can't
that.
be a cook in my last job. All of a sudden, I'm a
No,
CPS
for sure.
worker.
And there's vigorous backgrounding that's done, and that I think that they look for people with educational background and experiential background that would support the ability to be either an investigator or an ongoing worker in a case. But they have been experiencing a critical labor shortage for quite some time, and they need caseworkers as well, because even the best
So they
caseworker,
just take anybody.
I don't think I wouldn't say that. What I would say, though, is there's not any encouragement for someone who, say they do hire a licensed clinical social worker. That licensed clinical social worker, to maintain that license, has continuing education requirements and different things they have to do with the state board. There is a disincentive in the way, or at least there used to be, a disincentive to keep your license if you go to work for a child welfare agency, because they do so much internal training and so much internal, hopefully quality control, that they could take someone who has an English major, an English background, and teach them how to be an effective social worker. And they should have that kind of training in place. And I've seen the training that they employ, and it is, for an average person, probably sufficient to train them to do the job.
Do you ask a CPS worker what type of training you have? What's your background?
I don't ask that. The lawyers do all the time.
Okay.
The lawyers, very frequently in the course of a regular voir dire, when they put the witness on the stand, are trying to determine if they have the requisite expertise or experience level to be able to speak to it. There's always a discussion of how many years they've been a social worker, how many cases they've had, what their educational background is, why they're particularly suited to make an evaluation. And then the judge makes a determination of whether that reaches a threshold or enough to give their testimony enough weight.
Do you have, because we have a lot of litigants that tell us a lot of the same things about CPS, family court, all this.
I had a lot of clients that told me those same things.
Exactly. You've heard it all.
Yep.
But when do you have the litigants that complain about the same CPS worker?
Yeah.
If you get multiple complaints over one person, does that give you pause? Like,
Yeah,
maybe
that's
this person
typically
is abusing their
that's typically the circumstance where we
position.
look into it a little more closely.
Okay.
We have always been able to reach out to the supervisors within those units and let them know, I've got concerns. I've had 4 cases in a row now where I've heard the same thing about the same worker. Can you please look into it? We've always been able to reach out and ask for that.
And whatever happens to, because the ombudsman a lot of times doesn't answer these litigants or say they don't do anything.
And I heard you mentioning community oversight and everything. There is community oversight for CPS. There is actually already.
How does that work?
I'd
like to be a part of that.
The county has a relationship with the courts under an ordinance that we meet regularly. I'm currently the chair of that particular committee regarding policy and fiscal issues. And some of the people that report to that board are the community oversight for both.
We should get on that
What's
board.
the
For
name
both
of
juvenile
that
delinquency and juvenile
What's it called?
dependency.
Who appoints
It's
that board?
the Citizens Advisory Board or Citizens
Who
Advisory
appoints that?
Panel, CAP, I think.
The commissioners?
I believe the commissioners appoint.
Oh,
Yeah,
we could get on that board.
Hey, let's talk to your uncle.
The judges don't appoint to that. I believe commissioners appoint to it. But I get quarterly input from at least 2 oversight panels for both delinquency and dependency in the course of that meeting. And it's a public meeting. It's noticed. It's
When does this meeting? When does it
there's
take
one
place?
coming up in a couple of weeks, I think. Actually, it takes place quarterly.
Will you tell us when that is? Because
Sure,
I would love
can,
to attend
Yeah,
that.
if you want to reach out
and
to my
see.
JEA, she can let you. It's on my calendar.
So Judge Gibson, so a CPS worker can't just arbitrarily show up to somebody's home and take their children
For no reason at all.
they
without
cannot.
court order signed
Because
by
we
a
hear
judge.
this all the time.
No, that's not accurate either.
what's
There's a CPS hotline.
Okay.
Okay. And the vast majority of cases that are called in to the CPS hotline, one, it's anonymous.
Oh.
By statute, people are protected and encouraged to call that hotline if they observe anything they
Or
believe
if
to be abuse and neglect.
Or if they're
right?
BSing.
Right. And so
That
there is a
happens too.
whole department within CCFS that takes those 24/7 emergency calls and are trained to screen them at that point as to whether or not to send out an investigator. I'm not sure of the exact number, but I know it's the vast majority, and I think it's upward of 80% or more of those cases never go past the hotline. They're screened out at that point where someone who's trained to ask a bunch of questions and makes a determination as to this is something we're going to investigate or not. So that never even reaches the judge. Okay. Then the next level is those investigations that the hotline sends out. There's an entire unit of overnight off-schedule investigators who go out and investigate those things after hours. There's several units of investigators who go out during the day, regular business hours when they're on shift. At that level, they make a determination. And I would say that the majority of those investigations also never reach the court. The department is empowered to work with people informally. Say they go out and the house is a mess and they talk to the family and they go, look, you got to clean this thing up or else it's dangerous for the kids. We'll give you a couple days to do it. We'll come back and check on it. That happens all the time. People clean the house up, department goes their merry way. They may make a note of that family so that if another call out comes, and that's the thing, they do keep those records. If they are having frequent contacts with the family over time, frequent call outs to the police for alleged domestic violence, disturbances, different things like that, I regularly see in those reports on those removal hearings, there's a whole section that's devoted to past contacts with the department. And I can see there, and there's a list of how many times that family's been contacted by the department, whether it's been substantiated or not only by the court, but by the department. The department has the ability to substantiate something internally and work with the family and never take it to court. They only bring it to court if they feel compelled by their guidelines to remove the child.
How do they get the cops involved, though, if they don't have a signed court order? If I was a cop, I would look
what
at
if
that,
the cops
I'd be like,
roll up
I
with
can't
them?
get involved in this.
A lot of the times, I believe the police assist comes out on a welfare check. So anybody can call that into Metro or Henderson and say, hey, I'm concerned about a kid in this place.
The
Go check
welfare
it out.
I get.
And they'll go out and do the welfare check. Or if the department received the hotline call and they're trying to at least just see the kid, they may call for a police assist. And that's going to be up to the police whether they show up or not. That's a whole other thing you could unpack as well. You know, frequently there are orders from our courts to go and assist with picking the child up that for one reason or another, either it doesn't meet the form that they believe compels them to assist with, or they don't have the personnel to do it, or whatever reason. There's plenty of times where a pickup order or something like that.
You need a court order, though, right?
Yeah, you need yes, to do a formal removal. So if there's not an emergency situation, you need a warrant.
So how come they do it without one? Why does nobody challenges them?
And sometimes they just create a situation that there isn't a situation.
And that hasn't been my experience. The ones that I see, that come in front of me,
I'm gonna have to send you some.
The vast majority of them they're executing a warrant. They're executing a warrant that me or one of the other judges have signed. There is a category of them that don't. And in those cases, it usually comes in two ways. One, they went out to the house and they literally saw the abuse happening.
Right.
And they just pulled the kid. And that's an exigent circumstance, absolutely legal to do it.
Yeah.
The other circumstance is, and this happens a lot, where they have put out a warning to local hospitals that there is a family who is involved with the system who doesn't have their other children in their care because they're dangerous. And yet now they're at the hospital giving birth to another child. There is a hold that is potentially put on. And that is the source of a lot of the warrants that I see is the child's about to be discharged to this family that we're already working with who have not met the burden to get their older, less vulnerable children back into their care.
Gotcha.
Sometimes they hear about those kids in time to get a warrant before us. Sometimes they don't. And that's where it's real tricky. And they probably should rely on their lawyers to make a call as to whether there's an exigency or not. And they're getting better and better at not removing without first seeking the warrant.
But
oftentimes I get a warrant request where they absolutely didn't need the warrant. They could have just taken the child.
In those extreme circumstances that you're talking about. But otherwise, that should never happen without a warrant.
Right.
Okay.
Shouldn't
and if
happen.
it does, what do these people do?
If there's not,
what do these people do?
If there's not a present danger, if there's a reasonable time frame in which you could get a warrant and reasonably expect that child won't come to harm, then you should get the warrant.
So basically, if the cops and the social worker or CPS shows up at 2:00 in the morning in somebody's house,
sure,
they don't have a warrant, they could just tell them to go pound sand.
They could certainly try it. Everybody's free in this country.
And
They don't have to open the door, just like you don't have to open the door to the cops.
I don't even
unless
have a
they
front
have
door.
a warrant.
Not everybody has a lawyer as a family member who has told them in these circumstances don't do A, B, and C.
And
right?
how do they search your house without a warrant? Look under the bed, look in the closet, go through rooms.
Yeah.
How come these parents let them get away with that? I would have told them, get the F out of my house.
Yeah, that's the thing. I mean, a
People
consent
don't know their rights.
a consent search is always legal. And
Consent search. They'll never
consent
get
is
one
easy
from
to
me.
give, right? Consent's easy to give. If they say, may we come in, and you say yes,
Yeah.
you've just let them into anything that they can see in plain sight.
Plain sight. Not
If you
going
say to
open
them
the
then, if
door.
they then say to them, can I take a look in here? Yeah, go ahead. Can I open that fridge? Yeah, go ahead. You just consented.
Yeah.
Right.
I
right.
understand the consent.
And I
part.
understand that, for some people, the government actor standing there in their home,
It's
they
intimidating.
may feel intimidated,
Yeah.
compelled, or anything. But the Supreme Court of the United States made a decision a long time ago that most Americans know at least what their basic rights are. It's why, I don't know how many times I heard in the criminal cops, well, he didn't Mirandize me. And like, how do you even know what Miranda is?
Mhm.
Right? He didn't Mirandize me. You already know you have the right to remain silent.
Mhm.
You should have.
Yeah.
Right? I don't know how many times I said that to a client. You're like, oh yeah, so this is what happened, but they didn't Mirandize me. And I'm like, so what? You let them in your house.
Well, before
The
they
cocaine
search,
was on the table.
but,
That's baby powder, Judge.
Right? So
before they search though, and before
Yeah.
they ask, just like a cop,
Mhm.
has to read you rights, they should do the same thing to these
I'm
people.
not aware of a case that requires them to do that.
There should be though. In my opinion, that's what I'm saying. They
And-
should,
and
just like
that's-
the cops.
And that is something that it absolutely you have the right to advocate for. We have a process to get that put into place as law.
Yeah.
People could challenge it. Miranda came out of a court case, not of a statute.
Mhm.
The Supreme Court decided, yeah, you should have told him what his basic rights were. And that suddenly became the law for the entire country.
Yeah.
If the Supreme Court said, yes, a CPS caseworker on a welfare check should tell the parent, I don't have the right to search your home, but I would like to search your home, may I? Then that'll be the rule. And if that
It should
becomes the
be.
rule, I'll enforce it.
It
I'm the
absolutely
first one to tell everybody, I've been criticized for saying it. I believe that I am right.
Mhm.
I believe that I can take the facts, apply them to the law, and come to the correct conclusion. And until somebody tells me I'm not correct, I'm not going to doubt myself. How could I do my job if I can't do the basic function of a judge, which is to process the information, apply it to the law, and then make an order, right? But then if the Supreme Court tells me, don't do it that way anymore, I'm the first one to say, yes, sir, yes, ma'am. You are the court that reviews what I do, and you've just made new law for me. I'm going to do it the way you tell me to.
So over the years, we've had, and I'm going to say thousands of litigants,
Sure.
because I've been actively involved in this for years. And I tell litigants not to open up their front door. I tell them not to open it.
It's their
I said,
right to not
it's your
open
right
it.
not to open up the door. Don't open up the door. And I said, don't give anybody access to your home to look in there. That's just me. And a lot of them call me up and ask me these
Yeah.
questions, Judge.
Look, I was licensed to give that kind of advice,
Yeah.
and I gave that advice frequently to
Yeah.
people. I had clients throughout the years that I said, look, you're going to get in trouble if you keep operating the way that you operate. You need to learn from this experience and don't do that again. Right?
Absolutely.
What is it Jim Carrey said to his client in Liar Liar? Stop breaking the law, a-hole. Right? That's what he said. And sometimes people need their lawyer to be straightforward with them that way. But a lot of times, even these lawyers, they're already getting a situation that they now it's damage control, right? The client already rang so many bells. It's already in front of the fact finders. There's not anything you can do about it. So, I, as a fact finder myself, as a judge myself, I have to weigh the credibility of the people that are communicating in front of me. That's a new issue with virtual hearings and things like that. There's a lot of people that are having a hard time adjusting
I don't like your
to
courtroom.
the virtual to the virtual format, right?
I don't like your courtroom.
Because the screen's
We
not
need
facing
another
the public,
monitor.
right?
Yeah, we can't see.
I have no control over that.
You get IT
Our
in
building-
there.
well,
You're the presiding
You're the
judge.
presiding
Look, here's the
judge.
other
Tell you,
thing.
put
Call
3 more
Jerry
monitors
I
in
Reed.
preside
there.
over the court. the
Jerry,
court
we need another
employees.
monitor.
The building is not mine; it's the county's.
You could say I need some more monitors in
We've
here.
tried. We're asking for a new building to be built.
They want
need a-
18 more judges.
We
can
need a
put
building
couple
that's fit for
monitors.
purpose, right?
Your
we need,
uncle's
we
a
need more-
commissioner.
Well, hey, and everybody has got
Don't you
their
know a
constituency,
commissioner?
right? Everybody's got their constituency. We all have to operate within the law and talk to people in the proper contexts, and we will keep doing that. We'll keep having that conversation. But I think that's one thing that people don't realize. The family court facilities, the buildings that we operate at, our courtrooms, everything, the court doesn't own it.
Yeah.
The court doesn't control it. It's controlled by an outside building agency within the county. We walk into family court one morning and it smells bad. We got to call somebody from the county to come and fix it. We don't have our own employees that see to that. We don't have our own, facilities people. They work for other people.
Mhm.
They're great to respond to our requests,
You
no
have
doubt
one
about it.
screen and it's looking at you.
Yeah, because I'm the one who has to scrutinize what's coming through the screen,
True,
right?
But
Well,
we're in the
the-
audience. We need to see.
You do, yeah, but you also have the right to log in and see everything I'm seeing
And-
by
and-
Zoom.
In your courtroom
And
on
how-
the phone?
Yeah,
Because they
As
tell
long
you
as
you're not
you-
supposed to be on
as
the
long
phone.
as you're not recording me, I don't care if you log
And
in
how
on
does
your
the
phone and
plaintiff
watch it
and
there.
the respondent?
And I
Your
would love to
marshals
see.
don't like
I would
that.
love to see another public-facing monitor. If
Yes.
we can get somebody to pay for it, I'd gladly have it hung in my courtroom. I think you know this about
How
me,
much
Steve.
those
I mean,
things
over the
cost?
years, every time you've come into my courtroom, unless it's a case that I can't let you just sit down on, you're welcome to sit there and
I should
monitor
be
the
able to
whole
sit
thing.
in all those cases.
Hey, and that's something that's being vigorously argued right now in the courts.
Yeah.
My personal opinion is I'm a
SB
public
432.
servant.
Right.
I shouldn't say things off the record that I wouldn't say on the record. I should have no fear of the public taking a look at what's going on in my courtroom.
Right.
The privacy values that apply to this area of law specifically, though, dependency, is meant there to protect the child. It's meant to prevent the child's name from getting out, the child being unduly embarrassed. And it's ironic, our policy with delinquency proceedings, we've always let cameras in, the press in, observers in for those things. They're charged with not revealing the child's identity, not pointing the camera at the kid, different things like that. There are ways, and I think that's what the current case law is expressing, is that there are ways for a judge in control of his own courtroom or her courtroom to make rules regarding who's in the room as to what they can share in the public and what they can't. And as long as they abide by that, I don't see any reason why a person can't sit in a courtroom and watch all the
You
proceedings
let
all
an
day, every
attorney
day.
sit in your courtroom if it was a sealed case because
They're
argue
officers
that
of the
they're
court.
So
Yeah.
how could somebody like us
Mhm.
who court observe have that same type of access?
Ask the Supreme Court for it, maybe? I mean, that's where our direction's coming from
We would
right
have
now,
to-
right? With the Falcone case and other cases that are going on right now, I think the Supreme Court has signaled very clearly that when our court can be open to the public, it should be open to the public. And also, though, when the statutes say that our court should be closed, that we should treat that as a presumption of closed, but also keep the door open to a hearing and to tailor the hearing in such a way that we can make it as public as possible.
How much one of those screens cost?
I don't know.
Could you let me know?
I could try to find out.
I could probably get somebody to sponsor it.
I
I'm
could try to find
serious
I don't.
because you got one screen, you
Yeah.
got the plaintiff and the respondent.
This is the funny thing.
And
though.
they can't see
we're dealing
what
with
you're
government,
seeing.
though, Steve.
They can't
If
see
you-
what you're seeing though.
I got a perfect example. We love pickleball in my family, right? My
I remember
brother,
when that came
my
out.
brother's an
People
incredible
were trying to get me to go to
pickleball enthusiast. He wanted so badly to improve the lighting on one of our favorite courts that's owned by the city, right? And he went to them he says, I'll buy the lighting.
Mhm.
But the rules required them to seek a bid, open to the public for the same work and everything. When they had a member of the public who was willing to just foot the bill so that we could play later at night, right? But because of the way the laws are, the way that municipal structures, county structures work, there are processes that you have to go through. And so even for something as simple as donating a monitor to a courtroom,
Judge Gibson,
you
some
know,
courtrooms have 4 monitors in there, an overkill.
mhm.
You only have 1.
Are you saying like the RJC?
Oh yeah.
Because I don't know of any courtrooms in my building that
RJC.
have anything other than
Some of the
one
courtrooms
court.
have
Some
4.
have more.
Well, you're making my argument for me, man. We need a building that's fit for purpose.
Well,
Okay?
they should
And
employ
our
that
building that we're
building.
in right now,
Yeah.
we can't even house all of our family court judges. We've got 6 of them downtown.
Oh yeah, right. Mhm.
Right?
Yeah, we know.
We need
Of course you do.
upgraded, better facilities.
Yeah, you do.
And
You
we're
do.
not asking for a Taj Mahal. We're not asking for all the bells and whistles. We did submit some plans for a building that would see to the court's needs through 2050, but we also knew that that could be scaled back.
I might not be around in 2050.
Right. And no, and none of us will be. I mean, and that's the thing that plagues so many government buildings and processes and things is a more myopic view of what do we need now versus what are the need in a community like this that grows the way that it does. We should be employing some foresight.
You need another
right?
screen in your courtroom.
I would be happy to have another screen in my courtroom. If we can find another screen to put in my courtroom, I'm happy to have it wired up.
It's not just the people sitting in the pew
Yeah.
watching. It's the respondent and the
they do have to turn their head. to
Yeah,
see.
they can't see.
Now there's more to it than just a screen, though, right? That screen is wired into our court record program, JAVS. It's
about $5,000, you think?
I have no idea. I honestly have no idea. I got so many other things I got to worry about. I've never actually thought about what that costs. I don't know. As long as my computer screen's working in front of me, as long as I can see the people who need to make a record, those are the bare basic minimums that I need to dispense justice, right? Any kind of bells and whistles on top of that, I would welcome, I would love, but I don't have a lot of control over it.
Yeah.
You know?
I want to go back to
Sure.
some of these
We've
cases.
kind of wound around. I don't know if I fully answered one of your questions. or not, but
Well,
I'm
I
happy
want
circle
to
back.
go back to, and I ask a lot of judges this. You guys get so many pages. Your motion,
Yeah.
the evidence that goes with it, attachments, medical records. Some of
Yeah.
those medical records are
Thousands of
500,
pages.
1,000.
Yeah.
I mean, they're page after page. Do you read all of that every single case?
Yeah. These are my new best friend.
Okay.
I've had great vision my whole life, and now I can't read anything that's closer than this.
Happens to the best of
It
us.
sucks. It sucks getting old, right? But it's I use that to demonstrate it's no joke. We process thousands of pages of information, and in particularly, say your typical family court case where you're dealing with a family's whole history, all their assets, everything. You're talking pages and pages and pages. You apply that to a child welfare situation where you have to make decisions on a shortened amount of time with a massive amount of information that's coming in. So much of a judge's work is done off the bench rather than on. And that's yes, that's I work weekends.
He's in his chambers reading.
I'm in my chambers reading. That's one of the things that the pandemic did was it did create the ability to work remotely when you need to. And I can't speak for other judges what they do, but I work on a combination of in the building, out of the building, just by virtue of being the backup on so many things. I'm usually on call 24/7 anyway. I have a court issued computer at my house, a laptop that can log in, and I can do work from there if need be. I attend a lot of statewide conferences and different things by remote appearance. The new rules regarding virtual appearances are driving a lot of our hearings to be preferred to be remote. And so there is an incentive to do things from everywhere, right? I think that I should be in the building though, as often as possible. Most of my work is more easily accomplished within the building. I get there early in the morning. I might leave earlier than another judge does, but I don't typically take a lunch break. I eat at my desk. If I'm not on the bench, I am typically in my chambers working on something else. I will say on a Friday by the afternoon, I very frequently am free to leave the building while still being on call.
They got showers in that building?
No.
They don't have the fancy courtrooms.
Not even all of our courtrooms have bathrooms attached to
Judge
chambers.
Jones, he had a whole workout room in there.
Yeah, once upon a time.
Oh
Once upon a time. That's a conference room. We needed somewhere where we could put 26 judges, and so that got converted a long time ago. I actually helped move a lot of that equipment out.
Or the judges judges unlocking their courtroom doors now?
I hope they are. I hope that when a court is in session, the doors are unlocked. We have marshals who can stand between somebody coming from the outside to the inside. Most of us have some kind of anteroom between the courtroom and the hallway.
Like a mudroom.
Right. And so in internal chamber doors, I can understand reasons to have those locked.
Right.
External chamber doors on the hallway, if there's at least a marshal in the courtroom, I don't see a reason why it shouldn't be unlocked.
Some of them are a little lazy. They don't want to get up.
That's something that hopefully the judges are individually addressing with their own marshals. I know that, well, currently, I lost my marshal recently. He passed away. And so currently,
What took him?
a heart issue.
Oh,
It was sad, and it happened fairly quickly. It was kind of unexpected.
Oh,
And
was he?
he was too young.
Oh.
He was in his 60s. He was too young. But now I have some administrative marshals on a rotating basis, and I have to remind myself that they might not know my courtroom policy, and so I have to tell them, keep that outdoor lock unlocked while we're in session, and just keep an eye on it. If you see somebody in the anteroom, go and find out.
You got those hangers that you put on there.
We have, and that's something that
I've
just recently we have had installed, and I've had it installed on all the courtroom doors in the family division. We have a uniform signage that says, the court is not currently in session. Judges are attending to judicial duties other than the courtroom, right?
With those 6
And so, the judges, it still is just my recommendation to them to use them. Like I said, I'm not their boss, but we did provide them all with a uniform message so that members of the public who might want to observe, if they show up and they find the locked door, they've got a reason for it posted there. We don't have any court hearings currently going on. Well, I'm glad you do. I mean, I'm trying, and I think most of my colleagues are too. We want to deliver the best service to the public that we can, the best product to the public we can. And we would like the public to understand their perceptions to be accurate of what it is that we're actually doing. And I can totally understand someone going and walking through a courthouse and seeing not many of the courts actually in session and thinking, these judges must not be here. They must not be doing their job.
I think that sometimes.
I'm sure you do. And, it was interesting. I mean, I even fell victim to it from time to time during the pandemic. There were 5 or 6 of us that had to be in the building every day, regardless of the social distancing issues and all that kind of stuff, because juvenile delinquency, juvenile dependency, you have to have hearings every day because there's always kids involved in something, right? And so all those judges had to work from the building during that time frame. But the rest of our judges were at liberty to work remotely. And you could fall into the trap of walking down that back hall and seeing dark courtrooms and think, nobody's here. I'm the only one that's working, right? And, I had to check myself sometimes, and I would peek in to those courtrooms, and I saw a screen lit up and a judge on the screen, and I knew that the work was still going on. Interestingly, through the pandemic, 8th Judicial District Court wide, we managed our backlogs and we stopped the log jams much more effectively than other large jurisdictions. We reacted very quickly to the different directives that were coming down from the federal government and the state. We immediately got a virtual platform up and running, and we did not fall behind. Jury trials suffered during that time frame because you couldn't put people in a jury box. But bench trials, so the whole family division, it was for the most part business as usual. We continued to process them. We put in place an ability to process orders virtually. We have a program that's called Order in the Court. My JEA actually came up with the name for it. She won a little prize for it. And then I've always got, at any point in time, 30 to 50 orders in there waiting to be reviewed and signed off on. I process 30 to 50 of them a day. I was the millionth order on that one. It came out of my department. I signed the millionth order, and that was over a period of 3.5 years. Judge Hoskin, another of our family judges, signed the first order in that. And so family court judges are frequently working outside of the courtroom. I believe that civil and criminal judges are too. I don't have any reason to doubt that they are. So one of my jobs as presiding too, I think, is to get that out to the public that, I'm aware of what my judges are doing. And, if I see somebody slacking off, I'm going to point it out, and by and large, we are working our tails off. And it's hard. We've been a victim of our own success to some degree. We have created an expectation in the people of Clark County that things are going to get done within certain timeframes. And what's happened is we have been operating with far fewer judges than the statistics say we should be operating with. At the same level, though, as if we had those judges for so long, we've created an expectation that we can keep doing that, right? But with an elected judiciary, sometimes we get somebody into office who doesn't have any judicial experience, and there's a learning curve there, and things might slow down for a bit. We were talking before we started about, the benefits of an elected judiciary versus an appointed judiciary or something in between. There are some things that we can't account for. If the public chooses to elect someone who the public doesn't realize doesn't have the credentials, it then becomes the public's issue to remove that person from the bench, right?
You can't remove a judge from the bench.
No, I can't.
You could impeach them, but you can't
Right.
can't recall them.
You can't recall them.
And the Supreme Court made that decision.
Yeah.
I don't think the Supreme Court should have made that
Most
decision.
of the time, all you can
They should
do
have been the body to make that
is
decision.
report them to a judicial ethics commission. But people don't do it.
Yeah, and that only works when the media is involved.
Right. Of course. It's going to, the attention on a
Yeah.
particular situation is going to maybe get it more attention.
In fact, we got one tomorrow.
Oh, do you? Well, see, the by and large, though, the biggest complaints against judges to those kinds of organizations is either the judge yelled at me in court, like demeanor-based ones, that don't really apply to a misapplication of the law, but just the welcome environment of a courtroom, which is important.
It is very important.
Judicial temperament
Yeah.
really drives the public's perception of us.
Yeah.
But then the next level of those kinds of complaints is just somebody who didn't like the decision, right? The vast majority of those complaints, though, aren't associated with a misapplication of the law or an unethical communication. Those are the rare ones, but those are also ones that get the worst kind of discipline if they're reported. But a lot of the times, for whatever reason, the attorneys who see it happen don't report it. The members of the public that see it happen don't report it, or don't know how to report it.
Are your judges meeting open to the public?
Our judges meeting, no, they're not a public meeting. They don't fall under the public meeting statutes.
Could a judge invite someone in there as a guest?
Sure,
they have the presiding judge.
They got to clear it through me. I agenda items.
I like to attend one of those judges' meetings. Both of us would like to attend.
That's an issue of judicial security too. Okay,
you pat me down all
We'll
you want.
sign whatever we need to sign.
Well, this is the other thing you got to understand too. You give a certain amount of access to one member of the public, then
they don't do what we do.
They don't do what you do. And our judges meeting.
Look at this book.
Our judges meetings, by and large, are meant to handle internal matters with what's going on internally in the court. They're not required to be public. They don't fall under the public meeting. And so I don't think that my fellow judges necessarily are
Take a vote.
completely open to having just members of the public come into that particular meeting, because it is a meeting where we have the ability to speak our mind in a way that we can't otherwise. It can be lonely being a judge. You are governed by ethical rules that severely limit what you can talk about and with whom you can talk about. And we try to provide in that judges meeting an environment where the judges can ask those questions and have those conversations.
We definitely want to come to this one, though.
You know what? I will pass your request on.
I will sign a gag order.
This one's open to the public, though, right?
Which one?
The Citizen Advisory Panel.
Yes, absolutely.
Now
that is
we
our.
want to know
That
when
is our.
that is. We want to come to that.
It's advertised, but I'm certain I'll get a hold of it.
Where does it get advertised?
Wherever they publish the public meeting advertisements. Whoever does it. I think the DA's office takes care of it for that thing.
Okay, we want to know about that.
But that is called the Fiscal and Policy Committee.
Fiscal and
Policy. That is a public board that is subject to open meeting laws. They are advertised probably on a website, I would say, somewhere. There's a link provided, and there's an opportunity for public discussion at the beginning and the end of that meeting, where we invite public comment.
The agenda out
the
there
agenda
too?
is there, yeah, absolutely. That's part of
gosh.
the open meeting laws. The agenda has.
I attended one.
Where does this take place?
It's virtual. It's via a website. It's a virtual meeting. I attend for my chambers.
I attended one district court judges meeting, civil criminal. That was
Did you?
years ago when Phil Cohen was the PD back then.
Yeah, it's been some years.
Yeah, that's how I actually met Phil Cohen.
Is it?
At one of those judges meetings.
Yeah,
but I haven't been invited to one since.
Right.
I wonder why.
We look.
They should respect people that speak their mind and dig into it.
And if there is an appetite from the judges to hear from a concern from the public, I would make that absolutely available. We, from time to time, will receive a presentation from, say, like a drug testing organization, or we have had the DA's office and Las Vegas Metro come in and do a presentation on what they think the requirements have to be in a warrant in order for them to assist with a child pickup, different things like that. So we do have an educational portion of that meeting that is
talk about that
quasi-public. You want to come present your book?
Yes.
All right. I'll certainly ask.
I'm an author.
I'll ask them if they're interested in hearing about it, and if they are, we could invite you to it. But
what if they say no?
If they tell me no, we don't need to hear it, then it won't make it to my agenda probably. There's a lot of material.
Can I go
out
on there and smack them around a little bit?
What's going to stop you from doing that? You go on there and smack everybody around, right?
Okay, I have some real questions.
Sure.
Back to the medical records.
Yeah.
We went left somewhere along the way. You read all of these. You're not a doctor.
Mm-hmm.
Some of these records have incredible lingo in them.
Yeah.
How do you decipher those? How do you get through those? Because sometimes you have a doctor that's come out and rendered their opinion, and then a month, 2 months, months later, you have conflicting opinions from other doctors. So how do you balance that without being a doctor?
One, it's on the duty of the parties to put it in front of me correctly. Okay. Mm-hmm. They have to authenticate the documents. They have to present them in a way that I can then review them. I don't review those things ex parte. I don't review those. I don't go hunting.
Oh, okay? No, when they submit them to you.
When they submit them to me, based on my years of experience with reviewing those types of documents, for the most part, I can understand a lot of that lingo. However, if there is something I don't understand or something needs to be clarified, I will always let the parties know this is an area that isn't clear to me in these records. You need to bring a witness in who's got expertise, who can explain this connection to me. So that's how that would go. It can be put in front of me by motion, it can, or anything along that line. I will say though, however, that if it doesn't meet, because say, down the road, I've already got the law of the case. I've got established facts. I've got evidence that has supported it, and I've made a decision. Down the road, somebody says, you know what, those medical records are wrong. I've got these medical records. Well, they need to file a motion under the correct rules that say this qualifies as a reason that you can reopen the fact-finding portion of this situation, right? This is stuff that wasn't available at the time, or this is something that shows that there was fraud at the time, whatever. And if they have a basis for it, then they can present it. And if it cuts muster, right? If it is admissible, if it falls within hearsay exceptions and things like that, if it has a recipient witness, a doctor, an expert who can ratify what's in there and explain it, then we'll hold an evidentiary proceeding and I'll hear it. And if it changes my mind, it changes my mind.
So
if not, but that's on the lawyers. That's their job. They're supposed to get those things in front of me in the correct way. And until they do, I can't consider them.
But you have seen so many cases, not only as a lawyer, but as a judge now. Are you jaded after all the time? Do you look at these litigants and win these abuse cases and say, oh my gosh, you guys are guilty. You're guilty. You're guilty. What goes through your head? Is it automatically because the DA brings you something, there's CPS, they've taken the kids?
Yeah.
Do you look at them and say, oh gosh, here's another set of guilty people?
No, I treat every case as a new case. I can understand though why you would ask that question, because I think it's a fair question. I think it would be very easy to get jaded.
Yeah.
But I have a duty to not be. And so I spend a lot of time each year in continuing education, in learning how to evaluate my position, to re-examine my biases, things like that. I have an obligation to the people I serve to take a step back and take a look at it and say, am I being impartial here? And if I can honestly say I'm not impartial, I have a duty to recuse myself from that matter. There's all kinds of ways to deal with it. I try as best I can. My current position is presiding, and with our caseloads, I understand that there's not a lot of time to completely unplug yourself from being a judge, right? And to some degree, you're always a judge. The model rules apply to you whether you're on the bench or not. But I try to draw a line at some point in each day where I'm not thinking about that stuff anymore, right? I have a family. I have a life. I should be able to have a life. And so it's those times, and all kinds of people do all kinds of things to do it. I've got hobbies, right?
You're a Marine, they say you're a Marine
Yeah,
first,
right.
family later.
Right. I get God core, family, right there. Okay, so I have hobbies, right? That's how I divert myself. I practice martial arts. I'm a nerd. I play tabletop games. I do a lot of cooking and baking. That's something I picked up
in your house.
At my house, yeah. And I do those. I don't drink, so I don't have that diversion, right? So
I don't drink either.
Yeah. So but some people try to manage their life that way too. It's a constant exercise to try to clear your mental palate, right, and approach each new case with the fresh set of eyes. Now, that being said, there are patterns that reappear over and over and over again, right? But I've told a lot of people the thing about particularly abuse and neglect work and by and large in the family division, every time you think you've seen it all, you realize you haven't, right? There's new and interesting ways that people try to screw each other's lives up, or that children get abused, or on the other side too, though, there are new and interesting ways that people make things better too. And those are the most rewarding situations. Whenever I can reunify a family, that's the best. I do adoptions every week. I have adoptions every week, and it's on a Tuesday morning at 8:30, and it's the very best way to start a day because you see some kids finding a family that will protect them, keep them safe, and be there forever for them, right? And that's very rewarding. But it's not as rewarding as having worked with the family through their hardest time and getting their own kids back to them. I had a case today with a reunification where the department, and within the first 6-month period, and there were serious issues in this case, but everybody involved put their own personal stuff aside and focused on getting this child well and safe. And the recommendation was, we don't need to be involved anymore. And I sent that kid home without court oversight. And I do that all the time. I have people reunify, if not every week, every other week. And
I know there are many litigants
there are
and parents out there
that are successful,
where they've done the casework, they've done the therapy, they've done the plan and the class and all the stuff that they, in that first 6 months. And where there are some extenuating circumstances, there are some medical inconsistencies. There are things like this where the delay should not be. These where there is no danger. And I think that these cases should be hurried up and put on quicker on calendar so these kids that are little can go back to their parents.
Well, what about the ones that are breastfeeding?
Yeah,
the moms that are breastfeeding.
Yeah, that's a huge thing, right? Yeah. A lot of the times in that circumstance, we have to weigh: are they actively using drugs, and is it going to be delivered to the kids?
And what if they're not?
Situation?
What if they're not?
If not, then we are going to try to do everything we can to make sure the mom's having regular contact. There's a lot of literature that says that an hour-long visit 2 or 3 times a week might not be as effective as a 15 to 20-minute visit 7 times a week, right? As far as maintaining the bond. And I'm always sensitive to that. I always ask the question, why is this child not home? What can we do to get this child home? What do we need to do to make things safe enough? I'm always asking the parties, do you have family? Do you have friends? They may not be able to take your child as a placement, but they might be able to make themselves available for a couple hours a day to supervise your contact in the community. If you can give me that person, and they can agree to follow the rules of your contact, I'm going to order the department to make sure your child's available to you that frequently.
Go ahead. There's a vicious rumor out there. The room for all these years now, and nobody has not put a kibosh on it yet, saying that CPS pulls children so they could foster them out, or they could adopt them out,
legal kidnapping,
like legal kidnapping type of deal. Is that you ever heard of that?
Yeah, that's an urban legend, or sometimes it might be justified. Depends on your jurisdiction. What I can say is this jurisdiction. I have only ever seen maybe 2 cases in 20 years where I thought that's what was going on. Wow. And there are indicators, right? You can tell by who's involved in it. You know what I mean? If it's somebody up the chain that normally wouldn't be touching that case, I'm instantly suspicious of that. I want to know why. Why is this person who isn't on the ground every day doing this work suddenly injecting themselves into this proceeding? And I'm keenly aware of those kinds of things. And I have rooted that out once or twice. There have been a couple of circumstances in my courtroom where there became a conflict of interest that required another outside agency like the Attorney General's office to come in and represent a party so that we could examine and explore whether or not something untoward had gone on.
Have you ever had where there's racial targeting because the CPS worker is of one race and targeting the parent that's of another race?
We are constantly looking at issues like that, and we're constantly educating on issues like that regarding racial bias and that kind of thing. We are very sensitive to if there is a higher rate of removal within certain demographic communities, right? And when we see that happening and the numbers are showing that, yeah, there's a disparate impact on this community, we tend to impanel investigative groups or committees to take a look at that issue and see if we can resolve that problem. And that's a problem that unfortunately nobody's ever figured out really how to completely eradicate. And it rears its ugly head from time to time in child welfare across the country. There are continuing education for child welfare judges on that every single year. So we receive a lot of education on how to try to spot the red flags, how to try to spot when that's happening so that we can root it out. And I can tell you, whenever I've seen anything that is making me suspicious of that, I'm absolutely going to call that out and say, this looks like there's a bias here, right? And I have held evidentiary hearings to explore whether or not that was going on.
Do you think about your own kids every single time you have parents up there that have lost their kids?
Absolutely. I think that most people's experience with me is that they get empathy from the bench, that they feel like I am trying to understand their position. I'm trying to understand their situation. I don't know how many times I've had that conversation with the parent in front of me where I'm saying, look, I understand. I would probably be acting exactly the same way that you are right now.
Fighting for your kid. Yep,
fighting for your kid. And I've had conversations where I'm like, I would probably be acting exactly the same way. And if I were me, I would be telling you the same thing I'm telling you right now. The way that you're approaching this is not helping the situation. We need to try to redirect and figure a better way to interact. But at the same time, when people don't like their caseworker, I don't have the ability to reassign the caseworker. That's at the government agency. I don't have any control over that way. That's internal.
Control over that?
They do.
Just them?
Well, the county commission, I guess. They're a county agency. Right. So in Clark County, we're dealing with county. The rest of the state is dealing with the Attorney General's office. So it's a different situation.
You handle motions to recuse a judge when a litigant wants to recuse a judge for, let's say, bias.
Yeah, those go to the chief. Those go to Judge Weiss. No, they don't come to me. No. Those go to the chief unless he assigns me to hear it. I mean, he's able to do that. He can spread his workload if it's unruly. If he has a whole bunch of requests and needs a couple of judges to sit in and hear the issue, he can resign. That's the chief. That's the chief's role.
I told family court judges to go to the presiding before they go to the chief. Maybe I should just tell them just to go to the chief.
No, they should come to. I mean, look, I'm supposed to be the intermediary between them and the chief.
So you do handle it then?
Well, I'm supposed to handle as much as I can. Disqualification specifically, no. those go straight to the chief.
So what do you look for when a litigant wants to recuse a judge, saying that the judge is biased?
They want to disqualify the judge.
Yeah.
I look at what they're saying. I will, on the 1 or 2 times I've been asked to do it, right? It's typically the chief. But what I know, you look at what the litigant's saying. You also look at the judge's response. And then you apply the model rules to it and see if, a lot of it comes down to, would a reasonable person think that that judge is biased in this circumstance? There are some dead bang, look, it's a family member, they have a business interest. There's a whole list of things where it's an automatic, yeah, you're disqualified. But the judge's duty to sit is also something that gets weighed, right? Anybody can kind of color a situation. I think that judge doesn't like me, right? People have tried to disqualify me on religious bases because they know what religion I practice, and they think that my religion has a general view of a certain segment of society or something like that.
And it's going to blindside.
Yeah, and it's a ridiculous reason to recuse me. I'm perfectly capable of doing my job regardless of what my religious practice is. I think every American, has got to deal with that at some point or another
just
when
like
they're
politics.
doing their job. Right?
You got to put politics aside.
Yeah. So yeah, I'm perfectly capable of keeping something at arm's length, and I'm meticulous in identifying potential conflicts, right? If I have someone appearing in front of me and I think that there might be a perception that I might be biased, my rule is always to disclose any potential relationship and let them decide if they think that that's something I should recuse myself for. I'm capable of doing the analysis myself and saying, I can be impartial in this circumstance. However, I would understand that because I was at an event with this person and there was a picture taken and we're both in the same frame, right? That someone from the public might think that I have a friendship or some other relation to that person that might affect my ability to make a decision, right? I would disclose that and then make my disclosures as to the truth is, at best, we're a casual acquaintance. I don't talk to them outside of court or anything like that. I couldn't even tell you where they lived or what their, girlfriend or wife or husband looks like. I have no idea. And then typically, most of the parties in front of me are like, yeah, fine, no problem. But if someone wants to push it and wants to disqualify me, that's their right. I'll answer the disqualification motion with what I see the facts as being and whether or not I can be impartial or not, and then the chief will make a decision.
And just for the record, I wasn't talking about you. I was talking about.
Oh no, it could be anybody. Yeah, any judge is subject to it. Like I say, we have a very strict set of rules that govern our ethics. And if a judge is behaving unethically, they shouldn't be sitting as a judge. I'd be the first one to tell you that. If someone is clearly biased, they shouldn't sit on a case. If someone is clearly violating an ethical rule, they should be in front of the Ethics Commission and answering to it and figuring out what's going on. They should be sanctioned. They should be removed if that's what is needed. We made a commitment when we took the oath of office to do the job correctly and to be competent to do the entire job. And if I'm in a position where I'm not, I got 2 options. I need to be honest and step down, or I need to learn how to do it right? And I think everybody should be given a little bit of grace on a learning curve, right? Their first experience with this type of a case, they need to learn how that's managed. Fine. Our jurisdiction, the family division, we are district court judges. We're technically authorized to hear literally everything.
But nobody wants to be that guinea pig.
Right. Nobody does want to be that guinea pig. There are other jurisdictions, especially smaller jurisdictions.
No disrespect intended.
There's smaller jurisdictions where you can implement a one judge, one family policy. So literally everything, contracts, divorces, criminal actions, child welfare actions, same judge, same family, the whole way across the board. The volume in Clark County, and with the current personnel and how we're situated, no way can you do it.
No.
It's an ideal that we strive for. We try to do that in many cases. In family court, particularly, we're trying to get all of the same circumstances in front of one judge. When I was practicing, I had one client. He had 4 different cases in 4 different types of jurisdictions throughout the district going all at the same time. It was ridiculous. It should all have been in front of one person because you get no consistency, right, in ruling that way. We do our best to try to consolidate as much as we can and get them all in front of the same person. Sometimes, though, people would rather it not be heard by the same person, right? Especially if they already have a if there's already a proven ground in front of that person, right? They've been in front of me. I've asked for a change of custody 3 different times. They've made factual findings that prevented me from having that one. I want a different judge, right? But that might not be the right case because all of those findings may be absolutely accurate. That person probably shouldn't have had their custody changed. And if they got another bite at an apple with a different judge and got a different circumstance, that might put the child in jeopardy. So, you're constantly balancing all of these interests. And within the family division, I think the vast majority of our judges are every day doing their very best to do their job correctly. I know I do. And so, when it comes to issues like, should I be opposed to my next election? I'm going to be the first person to tell you, you deprive Clark County of a tried and true good judge, right? But at the same time, we have an election process and everybody's free to do it. And what I will say is I like my job enough. I'm going to run as hard as I can to keep it.
Yeah.
Because I think I can do the most good from where I'm at right now. I have seen so many families turn it around. I have reunified so many kids over the years to people that were accused of abuse. And there's always the downside. Every once in a while it blows up in your face. And that's part of the reality as well. You got to live with it and move on. But the vast majority of these cases where I've seen that outcome, it's the greatest and most rewarding part of my job. To see a family completely reunited and totally safe and to go home and fall asleep at night with no worry that I made the wrong decision. Right. That's the best part of my job.
What about these CASA attorneys? The ones that, is that the right?
The CASA
they represent the babies.
They're guardian ad litems, basically. They're a court-appointed special advocate. What they do is they speak to the best interest of the child. So a child's attorney, from the Children's Attorneys Project, they represent the child's desires. And that's what they fight for. A CASA is representing what's in the best interest of the child, and it's typically based on frequent interactions with the children. When I get a CASA report, you'll see in there, and they'll document how many times they saw the kid in the last review period.
What if it's an infant or two little ones? And what if there's no involvement at all and they sit in these hearings? Because I've witnessed this, just court observing at family court, where they sit on Zoom, they don't say a word, case, next case, and they don't say anything and they don't go visit the children. How do they even know? Why are they even involved? And some of these kids, when they go to Child Haven, are their medical records sent? Does that attorney make sure that Child Haven knows the medical records and needs of this particular child or that child? What if there's no involvement from that attorney?
If there are medical needs, they should be being revealed to anybody that's got the child in their care. Absolutely.
By that attorney.
With respect to our CASAs versus our CAPs and that kind of thing, the information, we are subject to the best information available to us. So the most effective CASAs are writing a report for every court hearing, and they're detailing all their context with the child and their opinion of what that child's best interest is. And I find those reports to be incredibly helpful, right? Because that's somebody that's laying eyes on the child over and over and over again. But if a CASA isn't laying eyes on the child over and over again, I'm probably not going to hear it because they won't have written up a report and they're not going to talk. And so their point of view is not going to be considered. They have to speak up, right? If I'm going to be able to weigh it for the decision I'm making. The children's attorneys, when you're talking about an infant who can't speak or articulate what their wishes are, there are national organizations that have discussed the ethics of representing children. In Nevada, they've adopted a model of substituted judgment in certain circumstances. So those attorneys are meant to look at the situation, take into account all the information that they have, and then determine what their client would ask them to do if they had the ability to do it. Whenever an attorney is substituting their judgment for a child, I'm going to scrutinize it a lot more closely.
Shouldn't they be talking during hearings, though?
The children's attorneys are always talking during my hearings.
I've not witnessed.
I have children's attorneys talking all the time. CASAs, I have not had as much input from them in the midst of those hearings. A lot of them are volunteers from the community and might be scared to open their mouth in court. So I'm trying to make my court as welcoming to their comments as possible, but I can't force it, right? I can't force a relationship. I can't force inputs.
Well, Ms. Phillips, we had Judge Gibson on for almost 2 hours now.
So
Oh my gosh.
we could
and
do another 2, but sorry, Judge. Thanks.
And he has over 200 views. The show is only shared 16 times, and that's it. So people are actually tuning in to listen to what Judge Gibson
I'm glad people are listening. I hope that, the public will reach out and ask questions. And we're constantly seeking to improve the family court experience for everybody. And Steve, you got a lot of years coming by my courtroom. My courtroom's open if it can be.
I need a key just in case. But I really do want to go into the judges' meeting at least.
Well,
I don't have to go in there for the whole thing.
Sure.
I can go in there and do a little presentation.
I'll float it with them and see what they say.
And walk
Don't
out.
let him badger you, Judge.
No, I'll float it with them and see what they say.
I'll go talk to your uncle if you don't let me in.
We certainly could coordinate.
I'll talk to your dad if you don't let me in.
If you wanted to.
I'll talk to Dave Gibson Sr.
I try to give as much equal access to the various media outlets and interested parties.
He's not even paying attention to me.
I know exactly what you're saying.
He's hearing this side. He's over here, though.
It's the same thing you always say to me. I'm going to tell your dad. Yeah.
Well, and your uncle, he's supposed to come on the show.
Oh, is he coming?
They agree. We haven't set a date, but he said yes, he would come on. So
I think you'll probably find him very interesting. He's got a lot of experience and a lot of knowledge about a whole lot of things. He was
mayor for a long time.
Yeah, he's mayor for a long time during probably one of the biggest booms in Henderson's history.
Before they had the term limits.
Yeah.
How long
he was limited. He did his 3 terms.
Was he limited?
He limited out, yeah.
Okay.
Yeah.
And this will be his last term. He'll term out as commissioner if he wins.
He hasn't told me what his plans are, so you'll have to ask him.
He's probably gonna hang out with your dad and go fishing.
He's got to do one more term.
Miss Phillips, do you have anything else for?
I do, but I'll let him go.
All right.
Next time.
My wife will appreciate it.
Sorry, Mrs. Gibson, we kept him too long.
Judge Gibson, we appreciate you coming out and taking the time and to talk to us about these very, very crucial issues in family court. Thank you so much for doing that. Yep. And at the same time, Mark is going to zoom in on you, and we know you have an election coming up next year. You can say whatever you want. Let us know who your campaign manager is. If you don't have one, we're more than happy to assist.
That's the funny thing. Until I'm actually
She'll give you a card.
Yeah, until I'm actually opposed, I'm limited in what I can do campaign-wise. Right. What I can say is I intend to seek a re-election. And I hope that I'll be retained. I hope that, I would tell everybody, pay attention to the RJ poll that comes out and some of the recommendations from the lawyers about retain or not. That's a useful tool. It's something that can help you watch programs like these, other programs that are watching the courts, see what the opinions about judges are and what they express.
Sorry, with the RJ thing, because I've watched them over the years.
Sure.
And if somebody has a attorney, because they go anonymous.
Yeah.
And if they had a bad rule, it doesn't even have to be a wrong ruling. The ruling they don't like, they're going to go and hammer you.
They will. And so it's not 100% accurate. Right. Obviously, anybody can say anything they want in that. But I think that a lot of attorneys do respond for the right reasons on those. And so it's helpful. I think you need to educate yourself, though, from any variety of resources that you can find about different judicial candidates. And sure, if someone's not getting the job right, I hope that members of the public will step up and run. The qualified lawyers will step up and run. As far as my particular seat goes, my position, I'm a good judge. You should reelect me. I care about this community. It's where I live. It's where I've always lived. All of my roots are here. I want good outcomes for families in these communities. But at the same time, if the public decides that I'm not doing a good job, then I think they have a duty to tell me so. So I would never try to stifle the electoral process. That's what the law is in Nevada. Regardless of my feelings about whether we always get the best results from that is something that can be examined. But I think the public made a good decision when they retained me after my appointment, and I intend to keep proving to the public that I know what I'm doing.
Well, thank you so much for coming on.
Thank you so much,
Ms. Phillips. Folks, that's David Gibson Jr., Clark County District Court, presiding judge, Family Division, Department L. And Judge Gibson, we go back many years. He's a good guy. I've known his uncle and his father, and they came from a good tree.
I appreciate that. I appreciate that.
But,
and anybody's welcome to come and watch me in action and see if that's a valid assessment of me, because I think that
we would like a lot of people to go and educate themselves and walk into these judges' courtroom and sit in the back and turn off your phones and observe the judge. So when you go to the voting booth, you be an educated voter, and that's all we're looking for: educated voters. Don't go by what anybody tells you to check off the box. Go by what you know. But if you do go by what anybody tells you to check off the box, make sure you go to organizations that do their research and know exactly what judges should be retained and what judges should be removed. This is Steve Sanson, Stephanie Phillips of Veterans in Politics. Until next time.